aspects of federalism in Malaysian practice. So let's get to know our team member.
Federal Constitution is a fundamental legal document that establishes the framework for the organization and functioning of a federal state. It outlines the distribution of power and responsibility between the central, which is federal government, and the constituent unit, which is state within the country. Typically, a federal constitution includes provision related to the structure of government, the right and responsibility of citizens, the division of power between federal and state entities, and mechanism for resolving dispute. It serves as a supreme law of the land, providing the legal foundation for the governance of the nation and often includes a Bill of Right to protect individual liberties. The Constitution is designed to be a stable and enduring document, but it may be amended through a specified procedure to adapt to changing circumstances. Malaysia is governed by a federal system that has certain unique characteristics. The Federal Constitution of Malaysia lays for the respective duties and responsibility of the federal and state level in a clear and concise manner. 13 state and 3 federal territories make up the nation, and each has its own legislative, executive, and judicial branch. Important features include a powerful federal government with authorities listed in the federal list and state autonomy in certain areas granted by the state list. The federal government and state government share concurrent powers. Malaysian federal system emphasizes the importance of Islamic law in state with a significant Muslim population, further reflecting the country's diverse cultural and religious landscape. This complex federal framework aims to strike a balance between diversity and unity, taking into account the various ethnic, cultural, and religious groups that make up the country.
One of the aspects of federalism in Malaysia is the supremacy of the constitution. According to Article 4, Clause 1 of the Federal Constitution, it says that the constitution is the supreme law of the federation. It also stated that any law passed after the Merdeka Day which is inconsistent with the constitution are void. In addition, according to Article 75, if there is any state law that is inconsistent with the federal law, the state law also is void. Thus, it really shows that the constitution is supreme than any other law in Malaysia. It can be seen in the case of Muhammad bin Daud and others and the government of Malaysia, whereby it revolved around matters of interference of parliament in enacting law trespassing state jurisdiction, as described in the constitution. In this case, the petitioners were charged under section 298A of the Penal Code for allegedly conducting an act which was likely to cause prejudice and disharmony among people professing the religion of Islam. They argued that such provision is inconsistent with the Constitution, as matters regarding religion should be governed by state, not the federal. They argued by upholding the list 2 of the 9th schedule, which shows that matters regarding religion are under state laws, not federal. The panel of judges then held that Section 298A of the Penal Code is inconsistent with the Constitution, as the crux matter of such provision pretends to be a law on public order, where in fact it is a law regarding religion. The power to make laws on religion is given only to the state legislative assemblies under Article 74 and 75 of the Federal Constitution. Thus, the provision is null and void except in the federal territories.
We can see in the issue of Nick Allen Zurina challenging the Sharia criminal legislation in Kelantan enactment. She said that she is just contesting the ability of the Kelantan state government to implement Sharia rules, arguing that the state government lacks the authority to enact crimes that are under the federal government purview. The case conclusion may have a big impact on Malaysia's use of Sharia law in the future, as well as on how the federal and state governments interact and how much freedom and rights each individual has. Additionally, as the subject of Islam and Sharia law is frequently delicate and contentious among the various parties, and population. It might have an impact on the political climate and dynamics in the nation. Currently, she is contesting the constitutionality and legality of the Kelantan Sharia Criminal Code 1 Enactment 2019, which has 20 provisions that cross over with federal laws and impose severe penalties for crimes like adultery, gambling, drinking, alcohol, and apostasy. Such laws, according to Nick Allen, are the province of the federal government, such as adultery, which has been provided under Section 498 of the Penal Code Section. Thus, the same law cannot be enacted by the state legislative assembly. Additionally, she asserted that the act infringed against her fundamental freedoms and rights guaranteed by the federal constitution, including the freedom of religion, equality, and life. Therefore, we can clearly see that under Article 4, Clause 4, the validity of any laws made by the Parliament or state legislator can be questioned in court. Every law inconsistent with the Federal Constitution shall be voided by the virtue of Article 4, Clause 1. It is because Articles 74 and 75 also have clearly defined the doctrine of demarcation of powers.
Malaysia clearly outlines the distribution of power between the federal government and the state government. This can be seen in the List 1 and the List 2 of the 9th Schedule of the Federal Constitution. The list above must be read together with Article 74, Clause 1 of the Federal Constitution state that the Parliament may make law with respect to any of the matters enumerated in the federal list or the concurrent list. Article 74, Clause 2 of the Federal Constitution state that the legislature of a state may make laws with respect to any matters enumerated in the state list or the concurrent list. Both articles clearly distributed the power of making laws to the Parliament in the federal level while the state legislative assembly in the state level. The application can be further explained in the case of Iki Putra bin Mubarak and Kerajaan Negeri Selangor and another, where the appellant challenged on the validity of Section 28 of the Sharia Criminal Offences Selangor Enactment 1995, CSO 1995. The section discussed sexual intercourse against the order of nature, which in the case of sodomy act of the appellant, it explained whoever found guilty of an offence and shall be liable on a conviction to a fine not exceeding 5,000 ringgit or to imprisonment for the term of not exceeding 3 years or to whipping or not exceeding 6 strokes or to any combination of the sanction. Later, the judge held that Section 28 of Sharia Criminal Offences 1995 of Selangor is ultra-vires of a federal law because of the existence of Section 377B of the Penal Code, which stated that whoever voluntarily commits carnal intercourse against the order of nature shall be punished with imprisonment for a term which may extend to 20 years and shall also be punished with whipping. As a result, the challenge of the appellant is succeed and being granted to appeal. The court later decided that federal law prevailed over the state law on the ground of exceeding the power enumerated by the Constitution in enacting the laws. According to this case, we could witness the separation of power between the Parliament and the State Legislative Assembly in enacting law. Any inconsistency of law shall be reviewed by a court in order to avoid vagueness and also inconsistency. This showed the importance of demarcation of power in discussing aspects of federalism in the country.
When Hadith bill was first introduced, there's a lot of confusion here. The confusion is, does the bill apply to non-Muslim? First, the Hadith bill does not apply to non-Muslim. According to item 1 of the second list in the 9th schedule, the law only applies to people who follow Islam. Therefore, it is not possible for a non-Muslim to be charged with a criminal offence under Islamic law in the Sharia court because the Federal Constitution clearly prohibits it. Furthermore, according to Article 74 Clause 2, the state can make law related to Islamic law, but the law must be in line with federal law. Otherwise, the law made by the state government could be void. But since the Federal Constitution specifically states that Muslims must abide by federal criminal law, it followed that they cannot be subject to Islamic criminal law for the same offence at the same time. The pith and the substance of the case are that Datuk Seri Abdul Hadi Awang proposed amendment to Section 2 of the Act to increase the current sanction, which state that fine of no more than 5,000 ringgit, a maximum sentence of 3 years in jail, a maximum of 6 whipping stroke, to a jail term of more than 30 years, or a fine of more than 100,000 ringgit, or a maximum of 100 whipping stroke. This amendment is to empower Sharia court. Unfortunately, these amendments are inconsistent with Article 75 of the Federal Constitution because both the sanctions of Sharia law and the Penal Code are different. Therefore, Hadith bill is invalid because it ultra-vires Federal Constitution. In the case of Iki Putra bin Mubarak and Kerajaan Negeri Selangor, the appellant has been convicted under Section 28 of the Sharia Criminal Offence Selangor Enactment 1995. Otherwise, in the Penal Code, the appellant can be sentenced under Section 377B. Based on both sanctions, Sharia law has a minor sanction than penal code sanction. Therefore, if the appellant is convicted under Sharia law, it will probably allow the repetition of crime by the general public. According to Article 75 of the Federal Constitution, Section 28 of the Sharia Criminal Offence 1995 was invalid because it violated the Federal Constitution. Thus, the appellant cannot be convicted due to the invalidity of Section 28 of Sharia Criminal Offence 1995.
As a conclusion, Malaysian Federal Constitution highlighting the provision of supremacy of constitution which is in Article 4 and the demarcation of powers which is in Article 74 and Article 75 play a vital role in shaping the country's legal and political landscape. Article 4 established the Constitution as the supreme law, emphasizing its authority over all other laws. Meanwhile, Article 74 and Article 75 outline the distribution of powers between the federal and state government, with Article 74 specifically addressing matters under federal jurisdiction. As we can see, in the case of Muhammad bin Daud versus Government of Malaysia 1988, the judiciary insisted the supremacy of constitution by affirming its role as the ultimate legal authority, preventing arbitrary legislative action. Similarly, with the issue of Nick Alin Zurina, challenging Sharia criminal legislation in Kelantan underscore the significance of constitutional supremacy in protecting individual rights. The case of Iki Putra bin Mubarak versus Kerajaan Negeri Selangor 2021 and the confusion surrounding Hadi bills further highlight the importance of a clear demarcation of powers between federal and state authorities as outlined in Article 74 to avoid jurisdictional conflict and ensure legal certainty. This constitutional principle provides a framework for the judiciary to engage in judicial review, safeguarding the right of individuals and maintaining the integrity of the legal system in Malaysia.